How can similar-sounding trademarks coexist without consumer confusion? Imagine walking into a store and seeing two brands with almost identical names. How can both exist without confusing shoppers? That's what we're here to find out. Trademark law is designed to stop people from getting mixed up about where products or services come from. When two trademarks sound alike, the main question is whether consumers might think they are from the same source. This is called the likelihood of confusion. If the answer is yes, the newer trademark might not get approved, and the owner of the first mark can take legal steps to stop the similar one. But sometimes, trademarks that sound alike do coexist peacefully. How is that possible? It comes down to a few key ideas. First, the law looks at whether the average person would be confused. This involves checking how similar the names sound, look, or mean. It also considers what kind of products or services are involved, how people buy them, and whether the consumers are very careful or not. If the products are very different, like a clothing brand and a software company, the chance of confusion is lower. Also, if the brands are used in different areas or markets, confusion is less likely. Businesses can also use what's called a trademark coexistence agreement. This is a formal contract that spells out how each business can use their similar marks. It might say one can use the mark only in certain regions or for specific products. It can also include rules about maintaining quality and how to handle disagreements. These agreements are legally binding and can be shown to the United States Patent and Trademark Office to prove both sides are working to prevent confusion. A simple letter of consent is another option. It's less detailed and just says one business doesn't oppose the other's use of a similar name, but it doesn't have the same legal strength as a full coexistence agreement. In real life, trademarks that sound alike can coexist if they are used for different things or in different places. For example, Pandora is a trademark for both jewelry and internet radio. Because these are separate industries and target different customers, there's little risk of confusion. However, if two coffee shops in the same city have names that sound alike, confusion is much more likely. In that case, the law would probably not allow both to keep using similar names unless they make significant changes. So, the key to letting similar-sounding trademarks live side by side is making sure consumers won't get mixed up. If the products are different enough or used in separate areas, and the businesses agree on how to use their marks, they can often coexist peacefully. Always remember, consulting a trademark lawyer can help you figure out the best way to protect your brand and avoid legal trouble.